Richard Williamson. I'm an estate planning attorney. This is my 30th year as an attorney. So this video is informational. It's intended to let you know what the basics of estate planning are so that you can use that information either with us or with your own attorney, however you choose. This video is about settling a trust. So estate planning is building up to the point where you want things to go the way you want and you want to appoint somebody to be in charge to make sure that your instructions are followed. But there is a whole nother process. The other process is settling a trust when someone passes away. And that's part of what we do here. And I'm asked the same questions and I pretty much talk about the same topics every time in a trust settlement consultation. So I thought I'd put this on a video to give you some information ahead. Different states have different rules on how you settle an estate. This is specific to California. And some of these are generalities, and some attorneys may say, well, we don't do things that way. That's fine. It's just a matter of a process. You got to go through a process to get a trust settled. So the first thing I always talk about when I meet somebody for a trust settlement in a consultation is most people walk in the door and they don't have their own trust, so they don't even know how a trust works, and here they are trying to settle one. So I have to back up and try to explain, well, what is a trust? So here's how I explain it. A trust is like a box that holds property with a set of instructions for what to do with the stuff in the box. The instructions always come down to who gets what when it's being settled and who's in charge. The types of property that go into a trust matter because some assets could be outside the trust, some could be within the trust, in that box. The ones that are in that box, in the trust, are the ones that the successor trustee has to administer. If there's life insurance outside that names beneficiaries directly, that's beyond the responsibility of the trustee. That's the beneficiary solve that. Same thing with an IRA or a 401k. If there's beneficiaries named on it, the successor trustee is not going to have to deal with that other than provide a death certificate for each of the beneficiaries so they can do the paperwork on making their own claim. Likewise, an account that is in both, hypothetically, it's in mom's name and it's in sister's name, and it's a joint account. Well, that's not in the box, and by law, that belongs to the sister. Now, sometimes that was just done for estate planning purposes, but by law, a joint account is the surviving owner of that account owns the account. So, but that's not something the trustee would have to deal with. So again, the three properties: real estate goes into the trust, financial accounts go into the trust, and tangible personal property.